My name is Amanda Howell. I'm a senior staff attorney with the Animal Legal Defense Fund, and I'm here to talk about the legal significance of the current challenge to California's Proposition 12, which is in front of the U.S. Supreme Court. The Animal Legal Defense Fund, along with a coalition of partners, intervened to defend California's Proposition 12. Proposition 12 really aims to make lives better for farmed animals when those animal products are sold in California. And a really large part of this legal challenge brought by the National Pork Producers Council, which is a trade association representing U.S. pork producers, involves a challenge under the Dormant Commerce Clause. So these legal questions, which will ultimately determine the legality of the California law, are now in front of the U.S. Supreme Court. My goal during this talk is to provide a bit of background on the issues, including Proposition 12 and the legal theory it's being challenged under. Making this kind of complex legal area a little bit simple, I'm trying to focus on what is Proposition 12 and why is it necessary for animals? And what does Proposition 12 do? Why are animal meat producers so angry about Proposition 12? What's happened in the courts so far, including at the district court and Ninth Circuit level? And what's the harm being alleged by the meat producers? And is it really a real harm, or is it simply them being angry at having to spend a little bit more money to have a little bit better lives for animals? We'll also cover the current questions before the U.S. Supreme Court. I'll aim to provide a simple but not simplistic explanation of this kind of odd area of law called the Dormant Commerce Clause, which is the constitutional clause at play now before the Supreme Court. Here's Proposition 12 as codified. It was passed in 2018. And let me hop back and say a proposition, it's kind of an interesting way of creating a law. It's a ballot initiative as opposed to a legislative bill that's voted on and passed by the people of the state. I think that's really important to highlight because it shows that the citizens of California thought that Proposition 12 was important. They voted their conscience and they passed this law directly themselves. About half the states in the United States use ballot initiatives, so this is not some odd thing, but it is, I think, a way of showing how important it was and how this is not some special interest thing. This is a popular vote. So this was passed by, again, by the people of California in 2018. Proposition 12 established just minimum space requirements based on square feet for certain animals, including calves raised for veal, breeding pigs, and egg-laying hens. And importantly, it's a sales ban, which means that it bans the sale of veal from calves, pork from breeding pigs, and eggs from hens when those animals are confined in areas below that don't meet those minimum space and square feet requirements. The text of Proposition 12 states that it's intended to prevent animal cruelty. I think that's really interesting and important because this is showing that the state of California and California citizens have this moral imperative, this moral interest, and are willing to pay more for products because they want to prevent animal cruelty, that is part of its stated purpose. It also is designed to address threats to the health and safety of California consumers, including the risk of foodborne illness. And foodborne illness is increased, risks of that are increased by extreme methods of farmed animal confinement. Proposition 12 follows something called Proposition 2, which had more generalized, not space requirements as such. It just provided that animals should be able to turn around and lie down and stand up and fully extend their limbs. Pretty, basic and minimal, I would say, requirements for animals in these factory farm circumstances. That said, the California Department of Food and Agriculture just recently published its finalized regulations for Proposition 12. Producers simply have to self-certify. They're providing information about their business, certifying compliance, and they're renewing the self-certification every 12 months. And there is a provision for inspection and audit. Proposition 12 was voted on by popular consensus within California, and the ballot measure was spearheaded by a coalition of people and organizations that care about animal welfare, including the Humane Society of the United States, Animal Legal Defense Fund, Animal Equality, the Humane League, Farm Sanctuary, Compassion in World Farming, and Animal Outlook. And it's these exact groups that helped pass the ballot measure that also intervened on the side of the state of California to help defend Proposition 12 when the National Pork Producers Council brought this constitutional challenge to the state law. I will say that I'm going to give a trigger warning now because I'd like to show what animals kept in intensive and non-Proposition 12 confinement looks like. So this is kind of why Proposition 12 is necessary. This is what traditional or conventional farming practices look like. This is intensive confinement, where animals are caged. They can't stand up. They can't turn around. As you can see, the veal calves, basically the width of their bodies. Gestation crates are these terrible things where mother pigs can't even stand up or turn around, and they're basically living the lion's share of their lives in these metal cages and these crates. And it's really, quite egregious animal cruelty to live your entire life in these circumstances. That said, for the animal agribusiness companies, the more cages that they have, the more they can prevent animals from turning around. And that means more animals under one roof, which means more profits to those companies involved in animal production. These companies often cite things like safety for piglets or mother sows to justify their use of things like gestation crates, but those supposed concerns really are not borne out by reality. And what's more, foodborne illness from pork sickens more than 500,000 consumers per year. That's causing thousands of hospitalizations and scores of deaths. And actually, it's a lot more in terms of risk for the food safety of the public, a lot more than for chicken or beef. Sufficient space for animals has been shown to be more positively associated with improved health and well-being for those animals, which seems like a common sense proposition. And that results in healthier livestock, if we want to call them that, which means safer products for human consumption. Conversely, studies show that offspring of sows subjected to extreme confinement in gestation crates suffer reduced immune resistance as compared to other piglets, which of course then presents a threat to food safety. And given the close nexus between pigs and human health, and I would say increased concern about zoonotic disease, it seems well within California's police powers to defend the sale of what Californians have decided are high risk and immoral products, and limiting how those products are sold within its borders. Proposition 12 is a landmark law. It's one of several in the country where consumers are basically not just voting with their dollars, but voting to legislatively cure intensive confinement and cruel confinement. And while it's this landmark law, it's also really doing the minimum of what we should do to address animal treatment on factory farms. The Dormant Commerce Clause. What is it? When does it apply? What does it prohibit? And what's the trajectory and what has it been? And again, this is the cause of action brought by the National Pork Producers Council trying to strike down Proposition 12. The Dormant Commerce Clause is a part of the Constitution. It's Article 1, Section 8, Clause 3. It authorizes Congress to regulate commerce with the foreign nations and among the several states. It's been interpreted by the US Supreme Court not only as an authorization for congressional action, but also, even in the absence of conflicting federal statutes, as a restriction on permissible state regulations. That's kind of the dormant part of the Dormant Commerce Clause. So first, in terms of what violates the Dormant Commerce Clause, a law that discriminates against interstate commerce or directly regulates wholly extraterritorial conduct is generally struck down without further inquiry. That's basically a per se violation if the law is discriminatory or regulates things that happen completely outside of the state. Another way that laws can violate the Dormant Commerce Clause is even when they even-handedly regulate, as in not being discriminatory between in-state and out-of-state interests. Second, a law that regulates even-handedly to effectuate a legitimate public interest and where its effects on interstate commerce are only incidental, will be upheld unless the burden imposed by that law on commerce is clearly excessive in relation to the putative legal benefit. And that's what we call pike balancing. In terms of when the Dormant Commerce Clause applies, I'll admit that this is a somewhat complicated and maybe unusual legal area. The Ninth Circuit decision in this case stated that although the Dormant Commerce Clause is not yet a dead letter, it is moving in that direction. What's more, Justice Scalia in previous decisions noted that the Dormant Commerce Clause, quote, has no basis in the text of the Constitution or in the historical record. And as long as the state's law does not discriminate against out of state interests, it should survive the Supreme Court scrutiny under the Commerce Clause. In terms of what the Dormant Commerce Clause prohibits, I think, it's pretty clear that it boils down to protectionism. The modern Commerce Clause precedent is, quote, driven by concerns about economic protectionism. And that's a quote by Justice Gorsuch. Case law to date confirms this. So it's really parsing it down to a very discrete application to prevent discrimination and economic protectionism. So the National Pork Producers Council wants to strike down Proposition 12 because, as they allege, it unconstitutionally and substantially burdens interstate commerce. They're saying that it requires out-of-state producers to conform to Proposition 12 standards, even for cuts of pork bound for other states where there's no consumer demand for Proposition 12 pork. So basically, they're saying that because California consumers only account for about 13% of the pork eaten in the US, California only has about less than 1% of the national breeding herd of pigs. So basically 99% of the pork consumed in California comes from pigs born on farms outside of the state. And the National Pork Producers Council is saying that it's to these out-of-state pig farms that Proposition 12 almost exclusively applies. At issue underlying NPPC's allegations is when determining whether a law is unconstitutional under the Dormant Commerce Clause, courts must first ask, is there a legitimate local interest that the state must establish? And in this case, it's preventing extreme animal cruelty, how extreme confinement creates public health and safety risks to California consumers. So first, the court has to look to that state interest, and the state has to establish it. And then, says the NPPC, the state, if and only if the state shows there is a legitimate local interest, then the court should turn to whether and how much the law burdens interstate commerce. And PPC says that if the law is based on an improper purpose and the state advances no legitimate local interest, and since NPPC thinks Proposition 12 is just California imposing its own morals on other states, then it must clearly meet its showing of burden. Burdens alleged by the National Pork Producers Council are things like substantial costs on out-of-state producers, significantly increased costs for consumers, increased production costs, businesses having to shift from one supplier to another, and saying that producers can't avoid transacting business with California because tracing or segregation of products are impossible. But really, looking at all of the burdens alleged by NPPC, what these burdens basically boil down to is just they're mad that they would be forced to engage in what they see as less efficient, read less profitable production methods. And really, that's not the right kind of harm for Dormant Commerce Clause purposes. In-state and out-of-state farmers are burdened in the exact same way. They all have to comply with Proposition 12 in the same way. So all the law is doing is preventing producers from selling animal products in California if they're not comporting with Proposition 12 animal raising requirements. On the side of the state of California and California's response to this Dormant Commerce Clause challenge, first, I think it's important just to say for perspective, Proposition 12 is really no different from long-standing state sales restrictions that require producers to use particular labels or conform to specific quality or safety standards. Think things like Proposition 65 labels, cancer warnings, conforming to specific quality or safety standards in the form of, having things must be that require refrigeration to be, refrigerated while they're in shipment. Also, I don't think we should minimize the fact that there's also a longstanding tradition of states determining that if a certain product is immoral or unethical, that they can then prohibit the sale or purchase of that product within the state based purely on moral bases. Think things like state bans on horse meat or dog meat, or cosmetics that were tested on animals, or products made using child labor. So while National Pork Producers Council really tries to minimize and invalidate this moral side of why California consumers and citizens decided to enact Proposition 12, I think that there's like a lot of precedent and plenty of laws on the books currently that, again, are just based on state citizens' moral concerns. Also, for background purposes, we really already have product differentiation in the meat and egg industries. So again, part of what NPPC is saying is that all of their supply would have to comport with Proposition 12 for any of it to be sold in California. But we already have things like cage-free claims and organic claims, antibiotic-free claims. And notably, even before the passage of Proposition 12, the USDA already prohibited extreme animal confinement in the federal organic food program. And even though those rules were withdrawn, they've been since reproposed. So if the organic program and if producers want to be labeled as organic, they're already going to have to either self-segregate their products or trace them back and have certain producers comply with those organic certifications and other ones might not. So it's kind of the same thing in terms of which products end up in California. It basically has to just be make sure that those products are compliant. On top of that, the state's police powers, that encompasses all laws in relation to persons and property within its borders, as may promote the public health, public morals, and the general prosperity and safety of its inhabitants. And that's a US Supreme Court case from 1896. So I think, again, this is very much within California's powers to pass a law that is based on concerns about animal welfare and concerns about the health and safety of its citizens. What's more, for Dormant Commerce Clause purposes, this state law is a neutral in-state sales restriction. It's non-discriminatory, and the national pork producers are not alleging that it is discriminatory, as in it applies equally to in-state and out-of-state products. What's more, clearly, Proposition 12 is not a price control or price affirmation statute. Because Proposition 12 regulates even-handedly, it is not discriminatory. For pike balancing purposes, increased costs to industry do not constitute an undue burden on interstate commerce. So that's the burden on one hand, the alleged burden. And on the other hand, you have to weigh the effects on public health and safety and interest in preventing animal cruelty. So I think that for both extraterritoriality purposes, and does the law only affect things that happen exclusively out of state? And the answer is no, it's just sales within the state. And on the other hand, for pike balancing, the putative local benefit, animal welfare, and preventing animal cruelty and food safety weighed against the burden on interstate commerce. And in this case, the national pork producers are really only alleging burdens to individual producers, not a burden on the instrumentalities or movement of products in an interstate setting. To recap, the National Pork Producers Council basically has two different Dormant Commerce Clause theories. And to sum up what the NPPC said in its cert petition to the Supreme Court, basically they're alleging that Proposition 12 requirements are inconsistent with industry practices and standards, generations of producer experience, scientific research, and standards set by other states. They also allege these requirements impose costly mandates on producers that interfere with commerce among the states and impose costs on pork producers that will ultimately increase costs for American consumers. NPPC also says that imposing these requirements on an industry that is national in scope, Proposition 12 unconstitutionally interferes with the functioning of a $36 billion a year interstate industry, and they're claiming that compliance with Proposition 12 will require new and less efficient methods of animal husbandry that will increase their operating, training, and veterinary costs. National pork producers are also alleging that they are going to have to comply with Proposition 12 standards, even if most of their products are not bound for California. And PPC's arguments really come down to this practical effect argument that they're making, that the practical effect of the law is to specify the means of production of goods to be used in other states and to alter the commercial transactions among out-of-state parties that are unrelated to California. They really take umbrage with any goal that Proposition 12 would have to change the national pork industry. Again, so we have extraterritoriality and we have pike balancing in terms of the Dormant Commerce Clause. First, for extraterritoriality, the Ninth Circuit has held that although that Proposition 12 may increase costs to consumers everywhere, it does not dictate the pork prices or tie California prices to out-of-state prices. So as such, it is not running afoul of the extraterritoriality provision. Again, NPPC is saying, though, as a practical matter, all suppliers must be in compliance with California standards. And they need to segregate their products, and that would increase costs significantly. And these costs or burdens fall mostly on out-of-state producers. I think that really the flaw in that argument is that that's a result of their business practices, not as a result of Proposition 12. Again, California's case is that, and it's what the district court and Ninth Circuit have agreed with, is that upstream effects don't constitute regulating conduct across the United States. And Proposition 12 is just regulating products sold in California, and that statutes are not invalid just because they affect in some way the flow of commerce between the states. The district court and Ninth Circuit also held that the following do not constitute extraterritorial effects. Things like burdensome requirements in order to sell in a state, that's fine. Upstream effects out of state, also fine. When the burden falls mostly on citizens of other states, that's also fine. Again, it's just if you want to sell your products in California and you choose to, then you have to comply with Proposition 12. In terms of the issues that the Supreme Court will be weighing in on for extraterritoriality, they are going to be looking at and asking themselves, are only laws that consist of price control or price affirmation statutes the only currently accepted way to impermissibly regulate wholly extraterritorial conduct under the Dormant Commerce Clause? Another way of putting that is it only price control statutes, laws that link in-state with out-of-state prices, and those that discriminate against out-of-state actors in favor of in-state actors? Is that the limit of what's prohibited by the extraterritoriality doctrine? For pike balancing, the Supreme Court will be looking at, is the harm to interstate commerce the same thing as cost increases to market participants and consumers? In that, does the cost increase to market participants and consumers qualify as a substantial burden on interstate commerce? They may also look at whether an interest in animal welfare, even outside of a state's borders, does that constitute a legitimate local interest? There are several things at play right now in the Supreme Court review and key questions that we have that the Supreme Court might be addressing. First, prior court justices like Scalia and current court justices like Gorsuch have severely limited the Dormant Commerce Clause doctrine, almost to the point of non-existence. So we're really questioning whether they will stick to their prior decisions or if they're going to walk back those prior decisions, given the politics at play here. The U.S. Solicitor General filed an amicus brief asserting that Proposition 12 does attempt to regulate pork production outside of California by banning sales in California. And they're saying concerningly that there is no legitimate local interest and really questioning the human health and safety benefits and almost completely negating and undermining the fact that those moral considerations could be a legitimate reason for states to adopt legislation. Even the more liberal justices may have concerns about limiting the Dormant Commerce Clause to the extent that the Ninth Circuit has here, in that the Ninth Circuit and Tenth Circuit basically have limited the Dormant Commerce Clause to price affirmation and price fixing statutes and the instrumentalities of interstate commerce. And these more liberal justices might seek to preserve the Dormant Commerce Clause as a viable challenge to certain state actions that implicate certain social justice issues. That said, there are a lot of strong arguments in our favor, and all the Supreme Court would have to do is to simply confirm longstanding Dormant Commerce Clause jurisprudence in the Ninth Circuit and other circuits like the Tenth Circuit. Our position, the California state position, and the interveners like Animal Legal Defense Fund and Humane Society of the United States, our position is really affirmed that, including arguments that pork producers, can comply, they can segregate or trace, and in fact are already compliant with other state laws that have similar bans on caged eggs and gestation crates. Our arguments are confirmed and NPPC's arguments are undermined via the numerous robust amicus briefs that have been filed on California's behalf in this case. If we win and Proposition 12 is upheld and the Dormant Commerce Clause is confined to pretty limited situations, there is the question of how this will affect other cases, including some of Animal Legal Defense Fund's work on tag gag cases or meat labeling bills that basically prevent plant-based products from using meat terminology. And I think that these two things do not run afoul of each other. And that's because for the other context where we're on the other side of the Dormant Commerce Clause, it would still be good law limited to the Ninth Circuit position would be that, yes, in terms of plant-based meat products, that is an extraterritorial law, a ban on speech, because it is an area of national regulation. There is a need for national labeling regs as evidenced by the existence of the Federal Food, Drug, and Cosmetic Act. And yes, we would be able to prove and have been able to prove that these laws are protectionist and designed to protect in-state animal-based meat producers from out-of-state plant-based meat producers. Plus, in terms of peg balancing, there's zero consumer confusion. And so this alleged government interest is nothing but pretext. And you weigh that against the burden on interstate commerce, which would be so significant that plant-based producers might not be able to be distributed nationwide or sold potentially at all. So I think that there is an easy way for us to be successful at the Supreme Court level, for the Supreme Court to confirm the Ninth Circuit's holdings, and for other cases to be able to thread that Dormant Commerce Clause needle. I mentioned earlier that there were a whole host of amicus briefs filed on California's behalf. I want to go through and highlight a few of the more significant and interesting ones, including several state AGs filing on California's behalf. This is important and probably notable too, because several of these states own similar to Proposition 12 laws, things like Massachusetts banning gestation crates for pregnant sows. The fact that animal welfare scientists and veterinarians filed an amicus brief, that really bolsters the substantial state interest argument and also that moral concern about ensuring minimum space requirements. On the side of public health and safety being affected by increased space for animals, the fact that the American Public Health Association has filed an amicus brief really does bolster the state interest in that there is a state interest in protecting the public health and safety and the food supply safety through Proposition 12. Notably, Purdue and Neiman Ranch, and also dairy producers, that really filing amicus briefs on California's behalf, that really undermines the NPPC's stated position that compliance with the law is completely impossible and it'd be too costly and things like that. Neiman Ranch took the position that producers can, will, and have already adjusted to consumer demands for pig raising without the use of gestation crates. The Supreme Court will be hearing oral argument on this case on October 11th, at which point we are optimistic that they will confirm the limits of the Dormant Commerce Clause, uphold Proposition 12, which will really protect not only animals, but citizens' ability to vote their conscience. Thank you.